Okay. Well, good evening, everyone. My name is Rena Lachlan, and I'm the Senior Director of Programs and Advocacy at the Epilepsy Foundation Eastern PA. It is my pleasure to welcome you to the third session of the Special Journey Solutions Navigating Key Options for Families with Special Needs webinar series. Tonight, you will learn about the importance of legal language and hear from Paul Feldman, who is a lawyer from Feldman and Feldman. As usual, you will also hear from our wonderful financial planning experts, Susan Walter and Bruce Sham. Before we kick things off, I want to officially introduce Paul Feldman. Paul Feldman is a founding partner of the law firm of Feldman and Feldman, which has served individuals and their families since 1988 in a wide range of matters involving estate planning with an emphasis on planning for the elderly and disabled. Mr. Feldman received a law degree from Temple University and also has his MBA and a Master's of Laws in Taxation. He is a past member of the Montgomery County Mental Retardation Committee and the Executive Committee of the Probate and Trust Law section of the Philadelphia Bar Association, where he chaired as an ad hoc committee on guardianship practice in Philadelphia County. He also previously served on the board of directors of the Delaware Valley and National Alzheimer's Association and the Association for Developmental Disabilities. Mr. Feldman previously taught as an adjunct professor in Temple University Law School's graduate tax program and is a frequent lecturer on elder law, guardianship practice, long-term planning, government entitlements, and special needs trusts. So welcome, Paul, Susan, and Bruce, and the floor is yours.
Oh, thanks, Rena.
Thanks, Rena.
I'm just going to stop sharing. I can put this up later if people want to see that. As she mentioned, this is a continuation from last month where we covered some of the basics and defined special needs trust, power of attorney, and some of those other legal documents. Tonight, we're going to be taking a look at kind of like their application in action. So we took some questions, we turned them into case studies, and we're going to kind of present them, answer them. But use the chat, send in your questions, particularly get them in early if you already have some in advance, so that we can make sure that they're folded in. But as we go along, as always, place additional questions in the chat. And I just want to mention that Bruce and Paul, their professional relationship goes back to the early aughts. They started being professionals at the age of 10, right? Okay. So anyway, yeah. So what I'm going to do is I will read the first case study, and then I'm going to hand it back to our expert here, and we'll have just a little discussion and think about how the legal aspects affect what's going on here. Case study number 1. My adult child with a disability, age 52, inherited $100,000 from a relative. I thought I had an appropriate trust set up for them in my will. But because the trust was in my will, what happens next? I don't want them to lose their waiver or Medicaid. We can also, let me just add, we can also discuss this one if the adult child is 65 or older, but let's just start with one who's under the age of 65 and see what happens. Handing it back.
Okay, that's a distinction because it goes to the heart of what is a statutory special needs trust. Now, a trust is just like having saying that you need a tire. There are tires for airplanes, there are tires for cars, lawnmowers. So trusts do different things. And the two trusts that we're concerned with is one that's generally called a supplemental special needs trust, and the other is called a statutory special needs trust. Now, what gets confusing is that there are other names for these same trusts. So sometimes a supplemental special needs trust is known as a third-party special needs trust or a common law special needs trust, while the statutory special needs trusts sometimes it's known as a first party or a third party, first party or a like a C trust or a payback trust. So what happened here is that this person tried to set up a special needs trust for their child. And you can set up a special needs trust under your will. That's called a testamentary trust. Or you can set up a trust that is a standalone that it becomes effective as soon as you sign it. The problem with what this woman did is that she set it up under her will, and it doesn't become effective until she passes away. So when this relative basically had this $100,000, it couldn't go into the special needs trust that she had created. So in that situation, since the beneficiary is under 65 years of age, we can instead use a statutory trust, which simply says that you're making a deal with the Department of Human Services. And because $100,000 would disqualify someone, that they will continue to allow that person to have benefits if they put it into this special needs trust, that whenever the trust ends, that they get reimbursed or paid back for the amount that they have done. So in a situation like this, it would have been much better for the relative to have consulted with this mother here, and then if she could have set up a standalone supplemental special needs trust so that this relative could say, I'm giving $100,000 to this special needs trust specifically, and that would have been the proper way to do it.
So what is the impact if the adult child is age 65 or older? What does that change?
If the individual is over the age of 65, in order to qualify as a statutory special needs trust, you have to be under the age of 65. So in that situation, they have another kind of trust that is similar to the statutory. It's called a pooled income trust, and that doesn't have any age limitation. So in that situation, what happens is that whenever that trust ends, the operator of the trust, usually a charity, keeps the monies. So, that's what we would have had to have done in order to preserve that child's benefits.
Do you have anything else to add, Bruce?
No, I think that's good. I do think that's good.
Okay. All right. Next scenario. My adult child with a disability lost her Medicaid when she started receiving my Social Security benefits several months ago. The reason stated is that she has too much income now. What can I do and how can I plan for the future? How do we handle overages and excess monies now, all of a sudden that's disqualifying them?
Bruce, you want to take that first shot? Since you're dealing with all these cases?
Yeah, no, that's why I thought it was very appropriate that you address it. I don't know, there's an echo, but I'm not sure where that's coming from.
Yeah, I think, Susan, if you don't mind muting when Bruce is talking, because I think it's coming from your screen.
Oh, okay. Oh, there you go. Okay. Yeah, Paul, we're seeing a lot of this now. And many of the families, as the children are starting to take their Social Security and they're getting that disabled adult child benefit, whoever is looking at it from Social Security is just immediately saying they're over the limit, particularly if the child is earning, some money on their own. And it seems like we're always serving two masters. We're serving the Medicaid master and we're serving the waiver master, right? Because it's a much higher limit if they have waiver. But if the kids are getting over $2,000, $3,000, that's over the $2,825 Medicaid limit. So I'm curious, and I know you and I have discussed this, but how would you advise some of these individuals of what to do? Some of the people on this call have already appealed with the Department of Human Services and were told that they've lost their benefit.
Well, it is obviously very topical and timely because this is happening now to a lot of individuals. When you have that income limit, which is 2825, that's the expectation is the Department of Human Services is that basically that is appropriate to still get all these services. But if you're above that, at least the thinking is that, you can start paying for some of these services yourself. So again, what is now evolving, because as I said, we're just dealing with these cases right now, is that you have to create a statutory special needs trust, and then you the amount of the overage above the income restriction subtracted from the amount you're getting has to go into that special needs trust, because that is thought to be, primarily dedicated for the purposes that the trusts were created. So then what has to happen is that you have to appeal, and then unfortunately, you have to get a lawyer involved. I don't know any other way. And what I do is I send this information to the Department of Human Services that says, hey, my client has agreed. In Bruce's example, if the disabled individual was getting $3,000, then I agree to every month put $175 into this statutory special needs trust, which the state has some interest in making sure that it's administered properly. So, and I say it's still evolving because these things are happening now and no one really knows about this, the way they're handling this. So, and I haven't yet ever had the opportunity to call her up with one of my clients and say, okay, here's the CIS number. They got disqualified. Here's the special needs trust. I would think possibly they may want some kind of document that says, I promise to put in $175 every month from my check into this special needs trust. But I can't say that with certainty at this point.
I have a question for you on top of that. Is it worthwhile to be proactive before the parent goes on and starts collecting Social Security to set up the trust in advance? Does that make any difference?
No, it does not make any difference whatsoever. Set it up, 6 months prior, the day before, day after, 6 months after. However, you won't qualify technically until you have it set it up and you have this approval to transfer into it the $175 in my example.
And Paul, aren't we seeing also the benefit of that? A lot of our kids, who are working, they have mandatory 401ks at work, even if they're not paying into them themselves. Their companies are putting 1 or 2% in, and that also at some point is coupled into the total resource limit. And we're finding that they have to, basically liquidate it, pay the tax, right, and put it in the first party trust as well. right?
Correct. I mean, the background with that, because I've dealt with it, is that as long as the person's employed and they're under the age of their full retirement age, then they don't technically have the right to any of that money. So when they tried to say that it's an available resource, we said, well, you try to get the money, we'll give you the right to try and get the money. And of
Right,
course, they
right.
then understood that it's not really available until the plan says it is.
Mhm. One of our guests is asking, why is it not certain whether or not this will work? Is this a new law? I mean, my understanding is that we haven't really seen it before, right? First of all, people are working longer, their social securities are higher, and our kids are living longer, right? I don't know that we've seen many of these situations before. I'm seeing a flurry of them right now where kids are in their 50s, their parents are passing, they're now getting 75% of the benefit. When they're getting 50%, it's not necessarily bringing them over. Many of our clients that at 50%, the child's benefit is still higher than the 50% of the parent's benefit. But 75% of the parent's benefit is a big difference. And I mean, Paul, do you have anything to add to that?
You know, it's just the way that these things go, that they pass a law and then all of a sudden that there becomes a flurry, as Bruce described it, of things beginning to happen. And they realize that, hey, we really don't have this set up correctly. But so this is what I'll tell you to do. I wouldn't be surprised in 6 months if there's something more formal that comes out, that goes to the county assistance office workers that say, hey, if they're getting this kind of child benefit from their parents' work record, that ask to see if there is what a statutory special needs trust. But that's not the way it is today, because I haven't ever really had the opportunity for any of my clients that came to me with this problem.
Right. So it's a new problem. Like I said, I mean, 40 years ago, the kids were still, the institutions in Pennsylvania were still open. I mean, right? The kids are living longer, healthy lives. And quite honestly, the parents are working longer, have higher incomes, and it's bigger numbers, which is what we're seeing. I mean, Paul, isn't this also why, to Susan's point, I mean, having it avoids the crisis of, again, getting the call from the sibling. What do I do? My parents died, that, and we've seen that. I had 3 of them this week.
Well, a lot of times parents feel that they don't want to burden their kids with this responsibility. And I think with some kids, they shouldn't be burdened with it because they have
Right.
their own problems.
Right.
But there are certainly a fair number of families where the sibling is very interested in preserving the exact same or similar quality of life. So the sooner you get them involved, and the more knowledgeable they are, and when you put in place what your plan is, then it's always going to be better than someone calling you up and say, "Oh my God, my mom died. What do I do?"
Thank you. Thank you. I don't
The
know if
other thing,
anybody
since
else
we're
had a. Go
the
ahead.
other thing that I would say in terms of that kind of situation is that in terms of residential, this is really way off course, but in terms of residential, I always say it's a heck of a lot better to plan early and try to establish your residential plan sooner while you're there, that you can help manage it, you can help your child adapt to it, and all those things. Whereas if it has to be done when you're not there in a way that isn't planned, it could really be much more upsetting than it already is going to be anyway. So getting back to the comment, yeah, it's always really important to plan.
And Paul, you just brought up another really good point that you've always shared with me. If the child is living in one of these community programs, they're usually paying 70% of their benefit to the program. And often what we're seeing is that when they're doing the Medicaid filing, they're not, sometimes the left hand doesn't know what the right hand's doing. And, you know, if the facility hasn't charged more, a lot of families want to just be billed, right? And they pay it out of the Social Security. And if the facility doesn't know now that the family has just gotten double the amount, and so then they're reporting to Medicaid the higher amount. Whereas if they're reporting the full 70%, there won't be as much excess, right? Because that would be considered an allowable expense. I'm in the right chassis there?
Yeah.
Right. So I don't know if that's confusing people. There is another question. Is there a limit to how much can be deposited into the statutory? No, there's no limit,
No,
right?
well, I would say that it's limited by how much resources that disabled individual has. You don't want to
Right.
put any of your monies in there
Right.
because your monies need to go in a supplemental special needs trust because
Right.
when that trust ends, it goes to other children or to other
Right.
remainder beneficiaries. So yeah, technically there's a limit, and that's the amount of money. Now certainly if, like Bruce said, if you retire and you have access now to your whole retirement account, yeah, you may have to take a hit, but you can then put it right into that statutory special needs trust to
Yep.
preserve the benefit.
Thank you.
Yes. All right. Case study number 3. In preparing for my minor child to turn 18, a trigger event for SSI and perhaps Medicaid, what should I do with the assets they have in their name? Additionally, I anticipate they will receive bequeaths from various family in the future. And then I have a sub question on that if you can answer this one first.
Okay. Well, the magical age at age 18 is when the Social Security Administration stops counting all of the family income for the household and instead just looks at the disabled individual's assets and resources. So that's what the magical age is. And when you get SSI, you automatically get Medicaid. What should you do? Well, the first thing is I always say you should really try to have as little assets in your child's name as possible. Technically, if it's his, if you transfer, there are transfer rules that cause a penalty. So I guess what I would say is that you should be very careful of when you allow monies to go into your child's name. And I guess what I would say is that now an easy thing to do is just to create an ABLE account, and you can put in up to the annual exclusion amount, which is $18,000 this year. Using that mechanism, you should be able to keep the amount of countable assets under the limits so that you will qualify. And again, in terms of the second question there, if you think that someone's going to be giving a bequest to help out the situation, either they give it to you, not to your child, or just like I said before, you create, just like case study number 1, you create that supplemental special needs trust standalone that is in existence. Once you sign it, you get a tax ID number because we all have Social Security numbers. So you get a tax ID number, and then you just open up an account at Vanguard or at PNC or wherever that put the money into. So you tell the relative, give it to me or put it into this trust.
Okay, so here's the kind of sub question B.
Susan, I was just gonna say real fast, okay? That Able account is really just, so new and really underutilized. And we're talking a lot about it now. But Paul, we do stress that it does not replace the need for a supplemental special needs trust, because we're only allowed to put up to 100,000, right, in that vehicle, or the children will lose their Medicaid again. So while we love it and we recommend it, and it's great for that, christening money, birthday money, bar mitzvah money, graduation money, it's not where we want to put our assets that we're going to pass to our child with special needs.
Well, especially because with an Able account, you have a payback. So
Exactly.
again, so we're only talking about the assets that are already in the name. It says, what should I do with the assets they have in their name already? So,
Right.
so once they're counseled, they should have no further money in their name. But I agree that, an Able account is not the correct solution for all situations.
Okay, I'm sorry, Susan. I didn't mean to cut you off.
No, please do. It's all good, important information. So here's kind of a sub question B. When applying for an adult over 18, kind of the same scenario, who was diagnosed later in life, perhaps this person is married, perhaps had a successful career, maybe even has children, and is now applying for Medicaid and has assets that are not sustainable for nursing care expenses and whatnot, that they will need going forward. Medicaid requires that look back of 5 years. How do you recommend it be handled? How do we not impoverish the entire family, whether this is an individual, a spouse, or spouse and children?
Okay, that's a very topical question as well. It really is the flip side of the coin for the benefits for someone who is special needs, a child, and so forth. These are for elderly, and they have Medicaid, and there is Medicaid for, they have waivers for a home and community-based waiver. They also have Medicaid for institutional coverage. I could probably spend a good 2 hours just talking about all those things. But I guess what I would say is that there are first some excludable assets that are not considered available to pay for these charges. The primary one is your home. They will not make a community spouse, the one who's well at home, sell their house to pay for the care of their spouse in a nursing home. So that's a big thing, and that often is the largest asset that the family has. Another excludable resource is a retirement account that is owned by the community spouse. So again, if the community spouse has a retirement account of 500,000, people are working longer, they have more contributions, that is retained by them. And there are a few others. So once we pull out the excluded assets, then we have the available assets. And for the available assets, it then depends upon, whether you're talking for spouse or whether there's no spouse. But if there is a spouse, then the community spouse can retain up to half of all assets, so long as it doesn't exceed $154,000. Now, that doesn't seem to be a whole lot, and it's really not a lot. There's also guarantees for income, but there are lots of ways that, going back to your point, that if you plan ahead and you see, seldom does something like this, yes, sometimes you have an a traumatic brain injury and the person's disabled. Often that's not the case. You see the disability growing or increasing. And so the earlier that you plan, the more flexibility you'll have to produce a better result in protecting the asset.
Paul, one of the things that we've seen, and this is particularly prevalent. I mean, obviously, any one of us can be in a car accident tomorrow, can suffer, a traumatic brain injury. We can get hurt. Any one of us could be predisposed to developing dementia. There are some, I mean, not that it's a silver lining, but having a child with a special needs also, since everybody on this call is in that same boat, aren't there some special rules about transferring assets into special needs trusts that we can avail ourselves of that are somewhat like silver lining here?
Yes, that's a very good point. That they have, they penalize transfers, a fancy name for gifts. So if you're giving money away that could otherwise be used for paying for the nursing home bill, that produces a period of ineligibility. Sometimes that's called the look back period, and the maximum period is 5 years. However, there are some excluded transfers that the government allows you to do. For example, they certainly allow a husband and a wife to transfer anything between themselves, and it does not produce a period of ineligibility. In addition, a parent can make a transfer of assets to a disabled child, and that does not produce a period of ineligibility either. Now, you could put it into a trust, but again, it probably would have to be that statutory trust. And sometimes if you make that transfer, you could be messing up your child's benefits just to qualify the parents' benefits. So the answer is that yes, that's one of the first things I find out, that if an elderly person comes in and they have a disabled child, then I have more planning opportunities to kind of shelter the assets than if the child was neuronormal.
And if a parent is raising grandchildren and they are the primary, paternal, does it count there too if it's a grandchild? No?
Nope.
Only natural child.
Only a child.
Okay. Thank you.
And something as interesting as well in that along those lines is that what I'm seeing more and more often of is that the disabled child who, quote, disabled child who lived at home with mom is now becoming the caregiver for the parent. And, in a lot of ways that works out really nicely. But again, the same things are happening, often with that.
If the grandparent adopts the grandchild, we see that a lot too. Children, drug problems, things like that. In that case, that is different though, right? Because the grandchild can get the grandparent's Social Security, right?
Yeah, if the grandparent adopts the grandchild, it becomes
their
their
child.
child.
Right. Okay. Thank you. But I mean, again, there's so many things that we're trying to deal with that sometimes, these little things, slip away.
I guess what I would say in summarizing all these cases is that, every situation you may think is exactly the same, but little things make a big difference in what you need to do. And it's hard to say, someone comes to me and says, well, my next door neighbor told me that they did this, this, and this, and this, and it did this, this, and this. I said, well, I don't know what your situation is with your neighbor. I couldn't tell you whether it's right or wrong. I can only tell you based upon what you told me. So, you really, and you have to be inquisitive. You have to attend these kind of webinars, the seminars, because you pick up a little bit. Now, you may not have quite understood everything I said, but maybe you'll go to someone and say, hey, they was talking about this supplemental special needs trust. I'm a little confused about this. And you gain a little bit more knowledge, which becomes a little bit more beneficial to you and your situation.
Paul, do you want to talk a few minutes? I know there's people on the call that have asked me, and again, many of these people you have appointments with coming up in the next few weeks, that their parents want to make provisions for the child, and they've sent us the parents' trust already, but would the parents have to do a codicil if we decide we want to set up trusts for the individual themselves? They have to talk to one another. Do you want to talk about that for a moment? Like how you handle that?
Let's just go back to the case study number one. I mean, obviously, that relative was not talking to the parent as to what was going on. So, what we try to do is we try to coordinate the planning. I mean, for example, why should the grandparents set up a supplemental special needs trust, and then the parents set up a supplemental special needs trust, so that you have two sets of books and you have two tax returns and you have two times the mishigas. So what I would say is that if you can coordinate what is happening, which again goes back to kind of advanced planning, not when someone's on their deathbed or just is placed in hospice, to advance plan what's going on so that you can produce a better result than if you have to do it ad hoc or quickly.
Okay, great. I think I just thought of one other question that somebody may be thinking, and please, for our guests, please put questions in the chat. This is a great opportunity to ask Paul.
To get free advice.
Yeah, free advice. If somebody has assets outside the country, they may have property outside the country, and ultimately it is inherited by the child. What's the impact there?
Well, again, I would say that if someone was not being truthful, if they never disclosed that, I would seriously doubt that anyone would ever find out about it. But I only know how to do things one way, which is the correct way. And so what I would say is it's another resource. And the question becomes, is it available? Meaning, can you convert it to cash to pay for whatever? And my guess is that a lot of times with these laws in these foreign countries, you can't do that. It passes down the line. But even if you could, it's very hard to sell sometimes in a foreign country. So I argue that it's not available. Obviously, I think that again, especially if you have property in a foreign country, not planning in advance to know what's going to happen with what the laws are there and how it's going to be handled here is really just doing a complete disservice to your family. And really, I can't think of anything worse. Actually, I dealt with one where someone had a Swiss bank account and no one knew until I picked up a deposit from way back when. And I went to trace it and there was, a couple $1 million there. So, and then once I found it, it took like 3 years to get the money to the United States. So, again, that's a circumstance where you really have advanced planning making a difference.
Thank you. Go ahead, Suze.
All right. This is about trustees. We don't have close family to be named trustees or medical and or financial powers of attorney. What are our options?
Okay. Well, there are a few. I'll go back a step and say what's most important to me when I talk about selecting a trustee or two criteria. One, they have to be drop dead honest, because if you have any doubts that about integrity, having a couple $1 million may not really help, the process. So you have to be absolutely sure that they're drop dead honest. And the second thing is that they have to have a good judgment, because they don't need to know about investing. You hire an investment manager. You don't need to know about a tax return, taxes. You hire an accountant or a lawyer. So, and if you're managing this trust and you run across things that you're just unsure of, you basically will know that. And if you have good judgment, you'll want to educate yourself as to what the proper thing to do is, because you're a fiduciary, and that means that you're managing someone else's affairs. So that's what I tell initially. If you don't have any close family members, you can get a bank or a trust company to be the trustee. Nowadays, if you have a guardianship or you have a special needs trust, their rules are that they have to have, it's got to be at least $3 million or they don't get involved. So there are some smaller banks that do, but they still have like $1 million. So what do? Well, basically, there are some professionals who act as trustee. And I used to do that and still do that for a number of clients, but I don't do it anymore because I have too much gray hair. So, I think that in this situation, oh, get out of here. My dog was drinking from my glass. Thanks. So basically, you can have a friend, but you got to be careful again about friends, because you have to just make sure they're trustworthy. There aren't a whole lot of options when you're in that situation. And so what I usually say is, you go to, like, what's happening now is that a lot of these operators of pooled income trusts, they will also serve as a trustee of the supplemental special needs trust or a statutory trust. My dog here wants to say hello here. So here you go. Okay. So basically, you can, and they take cases that are smaller. Now, you just have to be careful with any corporate fiduciary, because it used to be that you worked with the trust officer, worked with the family for 30 years. You're lucky if you have the same trust officer for 30 days nowadays. So, and there are some trust operators that run these pooled income trusts that are better than others. They're not all created equally. So you just have to ask around, and a lot of times, it's not the perfect solution, but in this crazy world of ours, I don't know what perfect is anymore.
Do you see co-trustees very often? Do you recommend that if that's a possibility?
Yeah, I mean, it's, sometimes you have a co-trustee where one individual serves with a corporate fiduciary. That way the individual trustee can kind of have some control over or equal say in investments or administration, distributions, things like that. You can certainly have, two people be co-trustees, siblings, but I'll say this, if they don't get along, having them be co-trustees won't make them get along any better, and probably a lot worse. So if you have co-trustees, you have to really make sure that they can work together.
I think you bring up a really good point, Paul. When if a corporate trustee is hesitant on letting us have a co-trustee with a family member, that makes me kind of nervous. It really makes me nervous. Like, why? I like when they work together and the family member is able to share. These would have been Bruce's wishes, right? I think that makes for a good a good working relationship. The plan of Pennsylvania, which has been totally revamped now, they had, that, as you say, they had a great run for 30 plus years. They had a little bit of a hiccup. I think they're back on track, and we can look to them for pooled trusts, right? If needed, for smaller estates, for families who don't have. I mean, these things do exist, but I have to say, like Paul said, it really is based on who is running it, right? That's what always made me nervous when they went through 6 or 7 directors in a very short period of time. It was very scary. I found that to be very scary, but I really like who's running it now. They've really got it together. But look, these are the things that Susan and I talk about, and Chris, when we're working with our families. We're here to try to bring these solutions to you.
So we've got about 12 minutes towards the top of the hour. If we think about these different trusts as the different vessels, the question is what different assets are best put in the different vessels, in the different trusts? Just
Okay.
be a quick hit on which.
Sure. Well, it's always kind of tricky to put a retirement account, naming these special needs trusts as beneficiaries of retirement accounts, because basically there are new rules that allow a retirement account to be converted, and whether you can take it out over 5 years or 10 years or your lifetime depends upon various different things. So I'm a bit cautious when we're talking about retirement accounts. I would never want to put in any kind of house into a statutory special needs trust, because at the end of the day, the assets get liquidated and you basically have to pay back the Department of Human Services. And there may be other people who were living there, who were taking care of you, or family members or whatever. So I'm really hesitant about that. I guess someone was just trying to tell me that they have a nice art collection and they wanted to put it into the trust. And I'm saying you're just going to create a nightmare for the trustee, because, it's not like you can have a bank account that, your money's protected. You have vandalism possibility, you have theft, you have a whole lot of things that the trustee doesn't control. So I would never really put any personal effects into a trust. In terms of stocks, bonds, I guess on some situations, you have to look at the income tax issues, and then you may want to, for example, buy I-bonds, that are inflation adjusted, that don't pay, any current income, so that basically it can grow if you don't need the income. Some people need the income, and so that you may want to get, a lot of fixed securities. So I guess, that there are, I would never allow someone to invest on margin or puts and calls, as some people do, because that's just not appropriate for a fiduciary.
Great. It's great. Such great information, Paul. I'm just wondering if anybody on the call has any other questions that we might not have addressed. Susan and I tried to, okay, here, there is a question now. With the $18,000 a year deposit to the Able Max, where do I leave? I'm not reading this right. Where do I house my death benefit from my life insurance? So that would go to the third party supplemental special needs trust.
That's right. I mean, just think of it this way. Statutory is first party. First party means it's my money. The supplemental is third party, meaning it's some third party's money. So the $18,000 should never be your money. You should open up a supplemental special needs trust, because there's no reason to give it back to the government, because it was never your child.
Right. I hope that answers the question. I mean, again, We look to the ABLE account for when the child is earning income, and every month they may be going a little bit over the Medicaid limit. They can put that in the ABLE account. If there's excess funds that they don't need, the ABLE account, it grows tax-free. The money comes out tax-free. There are some real nice benefits to having that, and it does allow our kids to have more than $2,000. So many of our kids are driving, they have cars, they have more expenses, and the government realized that, yeah, at $2,000, if I needed to get new tires, I needed to have a new engine, something fixed on the car, well, they need more than $2,000. So that's what we look at for the ABLE account. We don't. A lot of people think that, in the supplemental special needs trust, well, when the kids go to Wawa, they're calling us and asking, can we get them $5? That's really not what the supplemental special needs trust is for. That's where I would put the life insurance and the bigger assets that are going to be there to supplement, right? To supplement what our children are going to need so that they can live out their lives with dignity and the way we would want them to as their parents. Anything else that anybody's thinking about or that we didn't address? Or certainly if there's something private that you want to send to Susan and myself, maybe Susan, we could show the email addresses again, or we could put them in the chat. Many of you have already spoken with us and are scheduled to meet with Mr. Feldman. And I thank him so much for doing that for us and always being available to us with your questions. I don't know if Rena, you have some closing comments, or maybe you were messaged privately.
No, I didn't get any messages, but I want to thank you guys so much for that wonderful presentation and the discussion. And just a reminder, our next session is April 4th. We're going to be talking about taxes, so disability, special needs, and the IRS, talking about deductions, provisions, and planning. So hopefully everyone will join us. We will also post this on our YouTube channel, and I'll send everybody the recording link. And Susan and Bruce, if you have anything that you want to go out to the attendees, please email it to me and I'll pass that along.
Okay, yeah, we do have a piece, tax letter for next week that would probably be good because everybody's busy doing their taxes now. So there are certain deductions that we as parents of children with special needs can be made aware of and take advantage of. So yes, I will send you the piece, and you're welcome to send it to all the participants, please.
Okay,
And Paul,
great.
thank you so much for tonight. I really appreciate it. I know you just got back, and this was
Anytime.
all right.
No problem. All right.
Thank you so much.
Thanks so much, Paul. Thanks, Susan. Thanks, Bruce. Hope everyone has a good night. Thanks, everybody.
Thank you.
Okay, good night.
Night.